Welcome back to A Nice Place to Podcast, your go-to for all things Fountain Valley, where each episode we explore the fun, informative, and educational topics that showcase why Fountain Valley is truly a nice place to live.
Hello and welcome back to A Nice Place to Podcast Season 2. I'm your mayor and host for Season 2, Ted Bui. I'm happy to introduce your guest speaker for today, Attorney for the City, Mr. Colin Burns. In this episode, Mr. Colin and I will have a discussion on how we can begin to address issues regarding the unhoused populations or homeless in light of this recent Supreme Court ruling, as well as a discussion revolving around sober living home and the ordinance City Council adopted to establish a new regulations for group home that will go into effect on March 1st, 2025. So, Mr. Attorney Colin, for those who are unaware, can you please provide a brief descriptions of your overall duties as an attorney for the city?
So, Mr. Mayor, first of all, thank you for having me today. So my duties as attorney for the city, I get to serve as the city's general legal advisor. And having done this for a while, I'm very fortunate to have chosen the career path that I have. Unlike attorneys who go out and represent corporations or individuals who might have profit, money as motivation, as a city, we really get to do good. In the 20 years that I've been practicing, I've really seen how my clients are interested in the voters and not necessarily profit margins. So you really get to reach out and try to help the community, and you get to do good things. That being said, my role is to generally provide a first line of legal advice on all issues that cities face. And there are a lot of them. Fortunately, I have a team of attorneys back at my office that can help me out in their focus areas. But they generally fall into protecting public health, safety, and welfare, litigation, police issues, human resources, those types of things. What we're talking about today is essentially two of those issues. One is protecting health, safety, and welfare, and the other is being responsive and doing good things for the community. So I'm fortunate to have been able to do this for now 20 years, and the legal practice is a practice. So as I've gone through, the great thing about this area of law is that you don't always see the same thing twice, but as you go through, you try to see things for the first time less. And so as I've gone through, I've seen a lot, and the new topics are less and less, but there's always a new challenge, a new hill to climb. The laws evolved, state issues evolve, and it's fun, exciting, and challenging to be able to address them as they come up.
Well, I'm happy to hear that at least you have 20 years of municipality law. And I think you would want to share a little bit. I was told that your father was a prior city attorney for city as well. Am I correct?
That's correct, yes.
So we have a second generations of attorney in the city, back to back. So that is so great for sharing those history behind it. And Mr. Colin, can you also briefly explain the recent Supreme Court ruling addressing the unhoused populations?
The best way to explain it, though, is to give some historic context. So if we take it back a couple of decades now, there was a case out of Santa Ana called Toby versus City of Santa Ana. And in that case, the City of Santa Ana had a law that banned sleeping, laying on the sidewalk. And they did it to protect the sidewalk for its intended purpose. A homeless individual challenged that law in what was called a facial challenge, meaning the law can't be applied constitutionally or in a valid way at all. It went all the way to the California Supreme Court. The California Supreme Court says that a city does have the authority to ban people from sitting, lying, or sleeping on public right-of-ways, public sidewalk, in order to preserve those right-of-ways for their intended use, which is pedestrian bicycle travel. Now, the court left open the possibility of an as-applied challenge, which means even though the law on its face was valid, any person, homeless person included, could say that as it's being applied to me today, the law as applied is unconstitutional. And in the area of the unhoused, the laws are unconstitutionally applied when the person has a necessity defense. Necessity is a defense, it has been a California criminal defense for a long time. What it basically means is a person has no other option. So if an unhoused person can bring factually a defense that shows that when they got cited, they really had no other option, that's a defense to their case. And that's a reasonable, good, easily workable defense. And that's how the law existed for a long time. And many agencies, police agencies, were able to work within those parameters. They were reasonable and easy to apply. What officers would do is if they went out and they made contact with an unhoused individual, they would usually call the shelter first and make sure that there were available shelter beds. They would ask the unhoused person if they had somewhere to go, and if they said no, they would offer them a shelter bed. Only then, if the unhoused person refused the shelter bed, would the officer issue a citation, make an arrest, that sort of thing. And that process worked for many years. Then fast forward more recently to the past 10 years or so, there was a new case called Martin versus City of Boise. And the Martin versus City of Boise case looked at not necessarily necessity, but cruel and unusual punishments. And Martin was an unhoused person who lived in the city of Boise who raised a challenge saying to criminalize homelessness when there aren't enough shelters for every homeless person was cruel and unusual because it punished somebody for status. In other words, Mr. Martin argued that he wasn't doing anything wrong. He was being punished for the status of being homeless. Homeless, by definition, means a person has no home. So to cite them for being outside because they have no home, according to Mr. Martin, was a status punishment. And the Ninth Circuit agreed with that. And so what the Ninth Circuit held was that cities could not enforce an anti-camping ordinance, an ordinance that prohibited camping in public places, unless the city had enough available shelter beds for every unhoused person in the jurisdiction. So that created some challenges. One of the challenges was if you had 100 unhoused persons and 99 shelter beds, you couldn't enforce your ordinance against any until you had enough shelter beds for all. So you could literally have 99 unhoused persons out who you could not require to go to empty shelter beds because you had one more person than you had shelter beds. So cities really struggled to come to a solution following the Boise case. One of the benefits, and the decision has many good points. One of the benefits was it did help push for more navigation centers. As you know, the city of Fountain Valley has teamed up with the city of Garden Grove and the city of Westminster and built a navigation center to house, as part of a continuum of care, the unhoused persons living in what's called the central area of Orange County. And with that continuum of care system, what you're able to do is you bring an unhoused person in, they receive an intake, and a trained social worker analyzes and figures out what kind of services are needed, and they put that person on the right path to get those services. So that was a large benefit that grew out of Boise, Fountain Valley included. We have a navigation center that's a very well-run, respectable, nice place for persons who are experiencing homelessness. Fast forward now to the most recent Supreme Court case. The Boise case did make it to the United States Supreme Court, and the city brought the argument that cities really should be able to enforce their anti-camping ordinances even if they don't have enough shelter beds for every person, because it's not cruel and unusual punishment. And the Supreme Court, the United States Supreme Court, agreed. And a few takeaways from that case. First, they noted that enforcing against a person for camping in public places wasn't a status enforcement, enforcing somebody for the status of being homeless. What it was a tool that cities could use, along with a number of other tools that they have. The Supreme Court left open the necessity defense. So if a person really was in a situation where they didn't have anywhere else to go, the necessity defense could still apply, and that would be a defense to a criminal prosecution. But it really put a stop to the issue that cities were having where we couldn't enforce against anybody unless we had enough shelter beds for everybody. So what we've recently had was two things happen. Number one, we had a navigation center, so now we have shelter beds. And number two, we have a United States Supreme Court decision that says that we can still, and now again, enforce our anti-camping ordinances even if we don't have a shelter bed for everybody. So the recent Supreme Court case has really changed the dynamic, returned us back to the days of Toby, where everybody recognized there was a necessity defense. And officers can get back to the compassionate enforcement that they had, which was making sure before they make contact with an unhoused individual, they do call the shelter, they make sure there's a place for the unhoused individual at the shelter, and they offer that before using the heavier hand of criminal enforcement, and saving that for only those persons who refuse shelter after being offered.
Well, first of all, thank you for that well explanations. I think it deserves such explanations for the people in the audience can understand where the Supreme Court is, making a decision on this. And I agree with the Supreme Court because therefore now we have more consistent, right? Not one judge is saying one way, another judge saying it. It's going to be very challenging for the city how to navigate through this. So I'm happy that the U.S. Supreme Court got involved and made a decision. So now we have a basis as a city how to handle the unhoused populations. So I'm going to ask you follow-up questions. So how will this impact the unhoused population in Fountain Valley?
So we've seen a positive impact already. We have a lot of unhoused persons in the city who truly want help, and we reach out to those persons, and it's very satisfying to be able to get them into shelter and on their way to long-term housing. And in fact, the city's hired a company called CityNet to supplement police services, to go out and make contact with unhoused individuals and get them the services they need. Get them a driver license, get them into the navigation center, get them into programs to help them get long-term housing, employment, the things that they need to be successful. We also have a couple individuals who have refused any kinds of services and who really just want to impede public space and sidewalks. This tool, following the Supreme Court's decision, has allowed us now, for a person who doesn't want services when they're offered, for a person who we offer a shelter to go to and who refuses it, we now have a tool that we can use criminal enforcement. And we have been able to make a couple of arrests of persons who have refused services, and that has resulted in an immediate benefit, quality of life improvement, because we've removed essentially camping spots in the public places, the sidewalk and the park, and now those places are available for what their intended use was: pedestrian travel, recreation, those types of things.
Oh, great. Well, that's good to hear that we are able to enforce. We have a mechanism, like you said, we have several tools to address the unhoused population. That is wonderful. I think our resident is probably happy to hear that now we can physically go out there and enforce the law. Okay, now I'm going to ask you the follow-up questions, and this is particularly very important to me because I have a family. I have 3-4 children, and sometimes some of my kids ask certain questions, and I'm having a really hard time to answer to their questions because it's very sensitive, and I understand our limitation as well. So my follow-up question to you is, can you please briefly explain Ordinance 1607, which has established new regulations for group homes in Fountain Valley?
Group homes are another area where cities are trying to exercise some compassion. Group homes we have had in recent years. It's been called the Southern California Rehab Riviera, and group home operators have realized that it's very profitable to buy a single-family residence and take as many persons who are trying to exercise sobriety and put them into that residence to maximize their profits. And they do this to the detriment of their clients, the people who are trying to become sober, because you're not giving them a supportive single-family environment. What you're doing is you're putting them in essentially an institutionalized-like setting where you have way too many people living in a house. They have to deal with an overcrowding inside of the house, and there's also the negative secondary impacts to neighborhoods. And this has nothing to do with the fact that the persons inside the house are exercising sobriety. If I had a choice to live next to a house full of 5 people who were exercising sobriety and 5 people who are out drinking and partying every night, I'd choose the 5 people who are exercising sobriety. The issue with the overcrowding of homes is it causes impacts that are just related to having too many people. You have parking issues, noise issues, trash, smoking, those types of things. So it creates a use in a single-family neighborhood that denigrates the single-family neighborhood, that changes the nature of the single-family neighborhood to the detriment of the neighbors and also to the detriment of the clients who are trying to exercise sobriety. So what this ordinance does is it puts in some reasonable good neighbor regulations to try to get the group home operators to act like good neighbors, both for their residents, their clients, and for the people they live next to, and for the people who live next to the houses that they own.
Okay, so is there anything else that you think that this ordinance, when it goes into effect on March 1st of this year, that we can do anything? Because I know that there's some limitations on that from the state.
So certainly there are state and federal limitations, and we're not going to violate those. We don't regulate, enforce, go after people because of a medical condition, including the fact that they're exercising sobriety. We want to encourage that as much as possible. So what we look at is the business aspect of it. Now, the ordinance will start, we wanted to give a lead time on enforcement of the ordinance. We will start enforcing the ordinance in March 2025. And the differences I think that residents will see is that we are going to start requiring group homes that fall within the ordinance. There are state-regulated group homes that don't fall within the ordinance. They're already controlled by the state. And then there's this other group of houses that are called single housekeeping units. That's just a group of people who are living together, related or unrelated, in a family-type environment. Those we treat as any other single-family home. For those that fall outside of those two areas, the side where you have the overcrowding, where you have services being provided in the home, where there's a business aspect to the home that isn't already licensed and regulated by the state, we are going to regulate those. We're going to expect them to get a permit. We're going to expect them to follow the rules. And we're going to follow up with it. And we're going to make sure that they are complying with the new ordinance.
Okay. Do we have enough sufficient resource for that? Is that court enforcement that's going to do that enforcement, or who would be doing that enforcement?
It will be code enforcement, and they will have a lot of heavy lifting. Enforcement is always about resources. We have an excellent code enforcement division, and they're going to do the best they can do with the resources they're given. And I know the people in our code enforcement can do the work of 2 people in other code enforcement offices. So we really do have a code enforcement division that's able to be very productive, and we're going to rely on them for a lot of the work up on these.
Okay, there you have it. So on March 1st, 2025, law enforcement will go out and enforce on the group home, as our city attorney has just mentioned. And the personnel that will be going out will be our court enforcement. And thank you to our 2 court enforcement that we currently have right now that will go out and visit some of the neighborhood nearby in the future. So for those who obviously we have a limitation on the resource to identify where they're at, but you as an audience and the public, you could help us as well identify those group home that we weren't able to identify. You just call our city, the main line, and someone will direct you to our court enforcement and perhaps go out and give them a little visitation. So once again, I want to thank you to our city attorney, Mr. Colin Burns, for his wonderful update and news to our audience, which is our resident. And once again, thank you for tuning into our Season 2, Episode 1, a nice place to podcast. And we look forward to seeing you all on the next episode 2.
Thanks for tuning in to A Nice Place to Podcast. If you'd like to be a guest or have a topic you'd like covered, email us at fvproud@fountainvalley.gov. Until next time, thank you for listening.